Hi, my name is Wahyuni. I come from Universitas Bayangkara Jakarta Raya. On this time, I will present my paper entitled The Implementation of Principle of Justice in Resolving or of Consumer Credit Financing Dispute during the COVID-19 pandemic in Indonesia. For introduction, the COVID-19 pandemic has a major impact on the economy. Many people who have consumer financing credit agreement have been affected by the COVID-19 pandemic. They have difficulty making monthly installment payment. There is a case of dispute settlement for motorcycle credit financing in Bandung based on decision number 336 Perdata Gugatan 2020 PM Bandung. The, debt, the debtor has paid installment of 31 months out of the 33 month of the agreement. Due to the COVID-19 pandemic, debtors were unable to pay the remaining two last installments. The creditor's third party takes the debtor motorcycle on the road. The debtor brings the dispute to the Bandung City Consumer Dispute Resolution Agency or BPSK and the dispute has been decided. Creditor objected to the Bandung City BPSK decision and to the Bandung District Court. The Bandung City Court overturned the Bandung City BPSK decision. The problem is how is the implementation of the principle of justice in resolving consumer credit financing dispute during the COVID-19 pandemic in Indonesia. And for the research method, I use normative legal research with case approach. According to Peter Mahmud Marzuki, normative research is finding the truth, namely, or there are rules law according to legal norms, and if there are norms is the form of an order or the prohibition is in accordance with legal principle as well as whether a person acts the appropriate legal norms, not just according to rule of law or legal principle. Data is gathering from secondary sources such as the station, laws, journals, and books. And the station BPSK's station is as follows: state that the defendant or business actor is unable to prove his or her innocence. Sentences the defendant or business actor to return a motorcycle with the Honda type with brand year 2017 white color. Police number G6780AAZ. BPKB and STNK under the name of Siti Solihat, along with the company document or replacing them with a similar item of the same qualification and quality of the plaintiff within 14 calendar days from the date of this justice. To punish the plaintiff or consumer to pay in arrears the, that are still due to the defendant or business actor within a maximum for 14 calendar days from that of justice. All costs and career in the examination of dispute shall are borne by the state. And the claim of the petitioners or business actor are granting all of objective petitioners' application for objection to declare that BPSK Kota Bandung does not have the authority to adjudicate disputes. Declare that the Bandung City BPSK procedure is this case invalid. So that the Bandung City BPSK arbitration decision number 18 G 7 2020 BPSK Bandung has become legally followed, so it must be declared null and void. Declare declare the arbitration decision of the Bandung City BPSK number 18 G 7 2020 BPSK Bandung in excess of the lawsuit or ultra petitum partium. Declare that consumer financing agreement number 3000145517 date 3 June 2017 between City Solehat and PT Federal International Finance or FEF is valid and billable. In accordance with the valid term of the agreement and must be implemented. To declare, sorry, to declare that the Federal International Finance is not influenced and is not responsible for the, however, handover of the Honda Beat motorcycle, year 2017. White color police number G6780 AAZ. BPKB and STNK on behalf to City Soleha carried out by the respondent style objection to unknown person by PT Federal International Finance, stating that the handover letter of or document used by the respondent for objection to file the Bandung City BPSK is the official report and the settlement of false financing liabilities official report on the settlement of financing liabilities owned by the Federal International Finance. To finance the respondent objection to pay off the remaining debt fine due to consular delay. Declare that the respondent has legally and convincingly manipulated and reality by using a letter or document in examination, which was suspect of being fake, hiding the document of a decisive nature and series of deception relative to the case, which was decisive in nature. Declare the arbitration decision of the Bandung City Consumer Dispute Resolution Agency BPSK number 18 J7 2020 BPSK Bandung legally flowing and declared null and void or at least completely nulled. To punish the objective respondent to pay the entire cost of the case in the examination of the object requested special class 1A Bandung District Court. And just decision are granting the objection petitioner from PT Federal International Finance Bandung Bridge objection petitioner. Declare that the Consumer Dispute Resolution Agency (BPSK) is now authorized to examine and adjudicate this case, canceling the decision of Bandung Consumer Dispute Resolution Agency number 18 G720 2020 BPSK Bandung, date 11 Agustus 2020. Sentencing the respondent to objection city solely have to pay the cost of this case in the amount 376,000 rupiah. Case analyzed, the government has issued election regulation in the creditorial sector through OJK regulation POJK number 11 POJK 03 2020 concerning national economic stimulus as a counter-cyclical policy on the impact of the spread of COVID-19 on March 13, 2020. That the debt has a majority one payment of the total 33 times, so that the remaining debtors debt is only to installment. In this case, the debtor is entitled to legal protection and relaxation of relief in paying the remaining installment because he started experiencing problem when the COVID-19 pandemic began. The creditor action of using a third party collect by the remaining installment in a period during COVID-19 pandemic, and there are relaxation rule for the government. Attitude the creditor who is not responsible for the taking of the debt or motorcycle by a third party is very detrimental to the debtor, because this might not happen if the creditor has good faith in solving the debtor's problem, considering the debtor debt has almost been paid out. Decision analyzed for this case are: the judge only consider the objection of the creditor regarding the legal standing of the BPSK decision. The judge only consider the existence of the financing agreement according to the validity condition of the agreement, according to Article 1320 of the Civil Code. The judge did not consider The existence of the pandemic condition that had an impact on the debtor. The judge didn't consider that a third party took the debtor motorcycle on the road. The judge did not consider the protection of the consumer personal data, which should be confidential but known in detail by third party. The judge did not consider that existence of the financing company cooperation with a third party conducting debt collection. Conclusion for the research is it's not easy to translate justice into just decision in this case. The session has not fully considered substance justice, fairness of substance that is objective, honest, impartial, and rational consideration. Rational means according to reason or can be accepted by common sense. This justice has not yet been fully realized, especially on the side of consumers who have been affected by COVID-19. The debtor is experiencing difficulties and paying the remaining credit of the last two installment and motorcycle that have been taken by the third party and are charged with paying court fees. In solving that problem, the parties should be have the reach consensus by restructuring the remaining debt so that a win-win solution can be achieved for the parties. Thank you.